And thank you everyone for joining us for Litigation Basics episode number 6, Appellate Practice. My name is Stephen Reingold, and I will be the moderator today. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 7 of the slide deck summarizes this episode, and slide 8 provides a summary of the series. But speaking of the slides, we are not going to step through the slide deck in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Do keep the slide deck handy though, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Tim Anzenberger of Adams and Reese, Max Stein of Maxon, Mago, and Macaulay, Jeff Leon of Karen, and again, I'm Stephen Reingold, and I'm from Saul Ewing. Now, we appreciate that you're not spending your time or money to attend this webinar to hear infomercials about us. You can read more about us on slides 33 through 36. Now, this webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review and Max Asset. We thank you for your sponsorship. If you're attending the live premiere of this webinar, you could submit questions using the web portal. If you're watching this on demand, or you have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the episode, and we will do our best to get you an answer. Okay, with that, let's begin. So we're going to start with appellate jurisdiction. And appeals after a whole case is over are pretty straightforward, at least from a jurisdictional perspective. Now, interlocutory appeals, or appeals from judgments involving fewer than all claims or parties under Rule 54B, can be thorny. And just as a level set here, most of what we're going to be talking about is under the federal rules of civil procedure and the federal rules of appellate procedure. We will talk about some differences with state rules from time to time, and we'll do our best to indicate when we're doing so. Against that backdrop, Tim, let's start with you. So if you want to obtain interlocutory review, but the case doesn't fit squarely into any of the categories of Section 1292A, which I'll put up on the screen here, what are your options?
Thank you, Stephen. So generally, you've got two options at that point. The first is to obtain a direct certification from the district court under Federal Civil Procedure 54B. And that requires you to file a motion and have the district court enter an order that the appeal is that his order is final. So let's say you file a motion for summary judgment and you win on a claim. You get a claim dismissed as to a particular party. That party can file a motion for direct certification under 54B and ask the district court to find that that order on that one claim is final for appellate purposes. To do that, the court's got to find that his order did fully resolve at least one solid cause of action. So one cause of action is wrapped up and finished. And then the court also has to weigh the equities and make a determination that allowing this single order to be appealed satisfies judicial administrative interests. That's the first route. The second route is 1292B, which is extraordinarily tough. It's an uphill battle, but it is something that's available. If you read the appellate opinions on it, it's only available in extraordinary circumstances. And if you take this route, you also have to ask the district court first to grant your petition to have an interlocutory appeal on this basis as to a single order. The district court, you've got to convince, and this is, remember, the court that ruled against you, you've got to convince them that the order or the issue involved controlling questions of law with substantial grounds for a difference in opinion. Hard to get the court that ruled against you to find that. And the district court also has to find that an immediate appeal on an interlocutory basis will materially advance the litigation. If you win at that stage, you then have to get the Circuit Court of Appeals on board because it's in their discretion whether or not to hear it. So you got two bases under each one. You've got to go back to the district court. So it's hard to do, but those are some available routes.
Great. Max, let's move it over to you. Do you have an experience with using 1292A or B or Rule 54B in a manner that Tim described?
I don't actually, this is one of those instances where we will talk a little bit about state court procedure, because I recently did this in a state court case where a preliminary injunction, well, first a temporary restraining order and then a preliminary injunction were entered, and we took an appeal of that order. And I want to go back to the word that you used at the beginning of this topic, Stephen, which was thorny. And that is absolutely the right word to describe these things. So appellate practice is always a little bit, at least in my view, a little bit fraught, because the rules are so clear, yet difficult to navigate, shall we say. And in part, whereas we generally, as practitioners, we generally work with the rules of civil procedure on a pretty daily basis. The rules of appellate procedure might come into play every few years or so if you're not doing appeals all of the time. And so it's particularly thorny. And in this instance, that was exactly the case, because we were under Illinois state procedure, we were appealing a preliminary injunction, which you have a right to do, but you have to do that within 2 days. And when you file that appeal, you also have to file they're called a petition as well, to explain why you should win on appeal. So you have a very short turnaround within which to get that on file and to the court. The good news is, well, I suppose the good news is you're likely repackaging the materials you've already presented to your trial court. So hopefully it isn't too much. And your opponent then has 2 days to respond to that, at which point it will be considered fully briefed, and the appellate court, without oral argument, will rule on it within 7 days. So all of that is a very compressed time period that allows for a presentation of the issues, but not necessarily a, sort of take the deep breath, think about these things that an appeal often can be. Instead, you're basically just repackaging everything that you presented to the trial court, presenting it to the appellate court, and hoping for a different outcome.
Mhm. Yeah, Massachusetts has a similar intermediate appellate court where you can often approach it the same way. The time frame, I don't believe, is as compressed. That is shocking, and it probably causes a lot of sleepless nights. Jeff, let's move over to you, whether it's Illinois or federal. I know you practice in Illinois as well. So do you have any experience either seeking or objecting to requests for mandamus from an appellate court? And if so, what can you tell us about that process? No. You're on mute. No.
I'm glad you brought that up, because I was actually going to raise that as a third avenue. So it's called different things in different jurisdictions. In federal court, we call it mandamus. In Illinois, we call it a supervisory order. It's a little easier to obtain than federal mandamus. In California, they call it a writ, and it can be different kinds of writs, like a writ of prohibition, or different names depending on the particular action you want taken. And essentially what you're saying to the court is, the Court of Appeals, this decision is beyond the bound of judicial reason, and you need to tell the court to reverse it, right? It's not like the typical action you get when you appeal something. The relief that you're seeking is, basically a slap across the face from the appellate court to the trial judge. You have to be, yes, I have litigated mandamus and supervisory orders, a fair amount, and writs. You got to be pretty sure of at least one of a few things if you're going to pull that trigger. One, your relationship with the judge is already burned enough where it's not going to become materially worse in seeking a writ, because you can't pull punches when you file a writ. If you try to use temperate words, you're going to lose, because the standard for the court to step in at that particular point is they have to be outraged almost at how wrong the district court is. And that it would matter to do something now. And so you really have to lean in hard. In Illinois, when you file the supervisory order, you're actually naming the respondent is the court. And the judge doesn't usually file something in his or her defense. The other side does in defense of what the court said, but it's that personal. The other kind of circumstance you'd want to do it is where you can't unring the damage if you wait to appeal. And usually you see this in privilege rulings, right? And that's why you usually don't have to go the mandamus route, because if there's significant privilege issues, a trial court may well actually certify that as being narrow focused and won't slow down the litigation, right? Because the case can go on without that, and it will materially advance the litigation, and there's no way to fix it if they don't appeal it now. And if a judge refuses to certify that, I mean, this is one of the few areas where I think you'll find appellate courts, federal appellate courts, to be somewhat sympathetic to people who are seeking a resolution, because once your privileged documents are out there, maybe they can't be admitted into evidence at trial, but there's a lot there's a lot of damage if you don't get that dealt with. There's also another route to taking an appeal. We have a procedure in Illinois, and I know it exists in other courts, called friendly contempt, which sounds like the oxymoron of all oxymorons. But you basically ask the judge, who can't certify an issue, but what they can do, they make a discovery ruling and you want to appeal it. You say, Judge, please hold me in contempt. $50 fine ought to do it. And then you have an automatic right under Illinois law to appeal the contempt finding. And that is a route that is used with regularity in Illinois. It's kind of a gentleman's handshake kind of fiction that's used to get interlocutory issues up to the courts of appeals. I want to say a couple more things about this, because appellate jurisdiction we could do a 5-hour class on. I have litigated some of the most complicated appellate jurisdiction issues I think some of us have ever seen in some of the Holocaust litigation that I worked on. And you have issues regarding finality as to causes of action, as to parties, as to procedural statuses. And then sometimes you can bring along issues that aren't final with issues that are final, using various doctrines like the collateral order doctrine and stuff like that. It's crucial. If you're looking to file something interlocutorily, like before the case is over, you can't just study the rule. You have to study like the guides, right? The people who write about appellate practice, because you really need the help navigating it. The appellate courts are very miserly over their time. So they're looking to knock it out all the time. And frankly, the Seventh Circuit, almost every appeal will, the order clerk, as they call it, will issue an order saying, explain why you think we have jurisdiction over this, even if it's a final judgment. It's just like they want you to put it out there before they get the brief so they can review it and say, no, this isn't right, go away. So you have to be very, very careful in how you do it. And I'm going to say just one more thing. In federal court, there's one type of interlocutory order that you guaranteed have a right to appeal. Now, they can decide not to rule on it, but they almost always do, which is a grant or denial of class certification in a class action case. Because Congress recognized how important it is. Like getting a Class D certified after a trial keeps a big sort of Damocles hanging over the head of a defendant. And the courts have decided, and on the flip side, if a plaintiff loses class certification, $1 billion case can become an individual case for $2.24. So you have to get these issues resolved. And there are certain areas where Congress looks at that and says, yes, you have a right to appeal that before the case is final.
Right, that's very helpful. I can't think of a time I've ever asked a judge to hold me in contempt. That's a new one on me. I have to remember that one. So there is a
I will
lot.
say I
I
have
would
done
recommend it.
that and done the resulting appeal, and it was on a. It's often, as Jeff said, these are usually on discovery fights. This was in particular on a relatively novel question of how much information about a trust can you get in a divorce proceeding where one of the parties was the beneficiary of the trust but not the trustee, and unfortunately the dispute resolved itself just before the appellate court was going to issue a ruling. So we still don't know the answer to that question in Illinois.
I hope it didn't cost you more than $50.
It
So
did not.
Jeff, you made a good point about, how facile one needs to be with the rules and with the guidance that professors and others put out there to help us navigate what is a complex process. One of the areas that we should talk about is motion practice, because it is slightly different in the appellate context. So Tim, let's move back to you. What kinds of motion practice do you most frequently see in courts of appeals, and how do you approach them? And I'm gonna, after Tim, you answered, Max and Jeff, same question to you. Oh, you're on mute. Well, there you are. Okay.
Oh, yeah.
Yeah. Okay.
So the motions that I most frequently see in appellate courts and that I frequently also file most often are probably not the most exciting, but the most frequently one that's filed is a motion for an extension of time to file your brief, which is probably near and dear to a lot of practitioners' hearts because, once the briefing notice hits, you've got 40 days to get your appellate's brief in, then 30 days for your appellee's brief. I mean, it's a pretty tight window, especially if you've got a complicated appeal and a busy practice going on besides this one case. And for me, in the jurisdictions that I practice, the Fifth Circuit principally, it's hard to get a extension of time. And if you're not a frequent practitioner in the Fifth Circuit, you might be used to district courts or state trial courts that will routinely grant you an extension. The Mississippi Supreme Court will routinely grant you extensions, and usually it's the clerk's office that does so. But at the Fifth Circuit, it's tricky. You have to show good cause, and I'm too busy is not good cause. You've typically got to show something beyond that. If you are going to argue that you do have a busy caseload, you have to actually put the case names, the file number, the case number for it to show that those cases are live and what you've got going on. And in those instances, it could get denied, or they could give you a lot less time than you're asking for. So that's something to think about, especially if you don't have much experience at a particular circuit court. Another motion I see frequently is when you've got multiple defendants, usually with one plaintiff, and those defendants, they might have some nuances to their issues, but they all want to file one joint brief to sort of bring everything together and give the court just one persuasive argument to read instead of 5 to 10 different briefs that are kind of talking about the same thing. And you see that like in antitrust situations or some complex civil type stuff. But I've filed those and I've seen those often. And then more substantively, motions for leave to file amicus briefs, which if all the parties agree to allow an amicus brief, then you can file one. But sometimes they'll run into situations where the other side doesn't want somebody else tagging along and getting their say, so they won't consent. And so you've got to file a motion to show, if you're the amicus party, who you are, what interest do you represent, and why what you're going to say is going to matter to the appellate court. So those are the kind of motions I usually see most often.
Great. Max, how about you? What are you seeing?
Those are the kinds of motions that I'm generally seeing in the appeals that I've been involved in. I will say that, as Jeff noted, the Seventh Circuit is particularly stingy with its jurisdiction. I am pleased to say that the clerk's office there is less stingy with extensions of time, so that usually that at least that first motion for an extension of time will be allowed in my experience up here. Jeff, how about you?
So there are a few other motions. One of the most common, by the way, is we don't do pages anymore, we do words, but an extension of the word count. And that oftentimes that occurs in the context of a situation that Tim is talking about, where you'd have, say, 5 defendants each entitled to file a brief that's 40,000 words, and they'd say, we want to file one consolidated brief that's 80,000 words, so that's 120,000 word savings. Or you have issues where they're just incredibly complicated. I mean, the Holocaust case I mentioned, the briefs were 200 pages long. I mean, it was really extraordinarily unusual, but you often see people seeking more space. And courts usually don't want to do that because they don't want to have more work. And also, lessons over time have shown that when you force people into a particular page limit, you get better, leaner writing. On the jurisdiction point, probably the most common substantive motion is a motion to dismiss for lack of appellate jurisdiction. I mean, you can argue that in the brief, but you could be wasting a lot of time and money. If the court's inclined to agree with you, you will have nonetheless fully briefed, the substance as well as the jurisdictional question. And then the court will say, I'm not going to address the substance, I'm going to find no jurisdiction. So you can file a motion to dismiss for lack of appellate jurisdiction. And, the procedures under the rules are, governing that. There's another type of motion, which is a motion to consolidate appeals, either for briefing or for argument. There's, I don't want to say oftentimes, but there are certainly many times where there are appeals relating to the same issue that are up in a circuit at the same time. And you can move to consolidate them for argument. So, and the courts like that, they may not know it's going on. But what happens if you don't is you can have 2 different panels hearing really the same legal issue and coming to distinctly different conclusions, which is bad within, one appellate circuit. Finally, another motion type is a motion to intervene in an appeal, and that's usually available, only to the federal government. Because they'll claim they have an interest in the outcome. I mean, other parties can, in theory, intervene in an appeal, but they probably would already have sought to intervene at the trial court under, the federal rules of civil procedure down there. So it's not a comprehensive list, but, you can have a lot of motion practice. And also there's motions for sanctions, motions for attorney's fees. These are all, appellate motions.
Yeah, I'll throw one or two more out there in the bankruptcy context. Tim, these will be familiar to you. Leave to appeal and a stay pending appeal. You have to go to the bankruptcy court before you go to the district court, and you have to know your rules on that as well. That's sort of a common theme here for our audience: is know your rules and ask questions if you don't. All right, let's break down the
Steve, that raises one more, by the way, is saying it. When you file an appeal, you have to file some form of security, a bond, or you pay the judgment, into a trust account or something. And sometimes parties can't afford the bond, and you can ask the trial court to stay the bond requirement. If the trial court won't do that, you can ask the Court of Appeals through a motion to modify the security.
Let's get into the weeds a bit on briefing, because that is such an important part of an appeal before you ever step foot into court for oral argument, which we're going to talk about too. So let's start with what it is you're asking the appellate court to focus on, the questions presented. So Tim, back to you. it's sort of a loaded question, of course, but how important do you think the questions presented are? And as you're drafting them, what do you put into the mixes to how much of the factual detail you want to include in the questions presented section of the brief?
So I definitely think it's a critical part of your brief. It can be the most important because you are literally framing the entire appeal for the court in those very first few questions at the very beginning of your brief. It's your first opportunity to persuade the court and get them on your side, see the case how you want it to be. It could be the very first thing the judges read, or if you've got an oral argument and you've got two panel members who maybe haven't read your brief, they've at least read the questions presented. So it's critical in that way, right? And if you're the appellant, so the appellee doesn't have to include questions presented. You always want to. You always want to reframe things. But if you're the appellant and you frame some great questions presented that are persuasive and direct the case in your way, it's possible the appellee just goes with it, doesn't file their own, and then you're in a great position on your appeal. So I think they're absolutely critical. As far as what to include, I do like to include facts. I don't like to make them overly complicated, but I like to include enough facts so that you're not just asking the court. The question presented is whether the appellant was denied, due process. That doesn't tell the court anything. You want to explain, well, what happened below, and then ask the question. And then the question presented is, blah, 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 blah. And you want to use those facts in a way that it's going to get the court to see your way. You got to be fair with the facts, obviously, but that's a huge way to inject advocacy into this part of the brief. It can be one of the hardest parts of the brief to write, even though it's the shortest, because you've been working with this case especially if you were trial counsel, you've been working with this case for years. You know everything about it. Everything to you is important. If you're the appellant, you feel like you are wronged. So you've got a lot to say that you want to put in there. So you've really got to trim it down. And that's always hard to do, to take, an entire case and capsulize it in, a few sentences. It's hard to do, but if you can do it and you can be fair with those facts, it's a critical part of the brief.
Max, how do you approach the questions presented section?
So I agree with everything that Tim said, except for this part. I have no idea if we're right. And the reason I say that is because I have actually asked appellate court clerks and appellate judges whether they ever actually bother to read the parties' questions presented. And the answer is entirely mixed. So I absolutely agree with Tim. It is a critical part of framing the issues. I generally write a question presented as my first thing, and I will usually do it in a way that includes a little bit of facts to give that context that Tim was talking about. I will always phrase it in a way where the answer is yes, and that means I win. And I will then leave that there, and it's the last thing I look at before I file the brief, to try to make sure I go back to it, basically, to try to make sure that what I've said there at various points throughout the drafting process has survived. And part of it is a cross check, like, has the brief, as it's evolved, answered this question? And in doing that, I am trying to confirm that the brief answers the right question. And at the same time, that what I am saying at the very beginning of the brief is the question, is actually the right question to be asking. And so it is, as I say, I think it is critical. I think it may be the most critical, not because, at least in many instances, the judges or the clerks of the appellate court are actually going to look at it, but because it is how you, as the person drafting this brief and crafting these arguments, is thinking about what you're trying to convince the court of. And in that way, it's a good way to give yourself a sort of reality check and a cross check.
Excellent points. We're about halfway through here. We still have a lot of ground to cover. So Jeff, very briefly, any other useful practices for formulating your questions presented?
Yeah, I want to point out two different philosophies. One is just did the court err in finding plaintiff failed to state a claim for breach of contract? That is an issue, right? There's another way to write that. Did the court err in finding failure to state a claim for breach of contract because it found that consideration had not been pled, even though there were facts of XYZ, right? You're telling the court something more. And I personally believe it's better to go element by element that you're actually challenging than just tell the court, oh, we're challenging the dismissal of this cause of action. Like, tell the court what it's about. Max may be right that some judges or clerks skip right by it, but others don't. And not only that, but going to that level of detail helps focus you when you start writing. Like, what element am I challenging and why? And if you've already said this in a complete fulsome sentence, it helps you expand outward.
Let's spend a little bit, just a couple of minutes on another section of the brief, which is your procedural history, your factual background. They can be the same, they can be separate. Tim, do you see any benefit to presenting the entire procedural history of the case in a separate section, or do you just approach it chronologically and fold in, what the dispute's about and how you got through trial?
So I include it in the facts section chronologically. So my facts section, depending on what jurisdiction I'm in and the local rules allow for it, my preference is to have a factual and procedural background section that's broken up into subheadings. And I'll start from the very beginning of the background facts. And I'll go through and I'll use subheadings to sort of as guideposts as we go along through the facts section. And then I'll start with a complaint was filed. And then I'll go through the procedural history in that facts and background section, because when you're on appeal, what happened at the trial court, that's part of your facts. So I like to include it chronologically with the background facts. I just think it tells a better story. It's easier to follow than just having a very dry, separate section with the procedural history.
Max, how about you? How do you approach organizing your argument section?
So this is my first opportunity to use that most lawyerly of answers of it depends. And it depends in part on what the real thing being appealed is. Sometimes it is the procedure that is the cause of the appeal. And in those instances, I'm more likely to have the procedure broken out in a way that highlights what went wrong, as I would put it, or what didn't go wrong, depending on which side of the appeal I'm on, in the procedural history, and why it is that those facts might demonstrate why we should win on the appeal. In other instances where, if a sort of a more standard appeal with what I'll call more garden variety issues and garden variety events down below at the trial court, that procedural history may not need to be highlighted the same way. And as Tim put it, it really does become part of your facts in a way that you don't have to break it out. And so often in those instances, I will include it. And I will also say that I go back and forth about the way to tell the story. Is a pure chronological telling the best way to do it? Or is it better to jump around in the chronology so that you create the context before you get into each one of the pieces of it? And there too, I'm going to use that lawyerly answer of it depends, because I've found it in some instances, a pure chronology is the easiest and most effective way to present the questions and the issues. And in other instances, I have found that the jumping around actually really does a very good job. I guess what I would say to anybody listening who's trying to figure it out for the first time or something like that, do it chronologically, because that's the easiest, and you will know what to put where. And once that's done, if that doesn't seem to be working, that's when you need to consider about whether you should be moving things around and putting things in different places.
Jeff, how about you? How do you approach it?
I mean, I almost always write a separate procedural background section. And frankly, as Tim mentioned, in many jurisdictions, that's not optional. In California, it's a required section of the brief. But I think that you have to do it for a few reasons. One, I think we talked about how miserly of appellate jurisdiction courts are. One way that they can quickly verify certain easy questions, is looking in the procedural background section. Oh, final judgment was entered on this date, and they filed this appeal 96 days later. Okay, it's untimely. Get it out of here. It also allows the appellate courts to see how judged the case was, right? If there's a lot of action going on and the judge touched the case in many ways, like there's a psychology to appellate court judging, but you have a little more trust, right? And if the judge was constantly involved, you have a little more confidence that the judge knew the facts, right? Knew what he or she was doing. And you may approach things a little deferentially, whereas if you see there was very little touching by the judge, and the judge just kind of got rid of the whole case very quickly, you may look at that with a little more jaundiced eye. And it can be hard to follow that if you're interweaving that into your factual background. But I do think the situation Max discussed is important. A lot of times the appeal is purely over the procedure. Where, for example, you're appealing in summary judgment. Once summary judgment is filed in federal court, you cannot take any discovery without leave of court. You have to file a motion, it has to be detailed, blah, blah, blah. If that's what your appeal's about, well, all of the procedural stuff that preceded the denial of additional discovery is your fact section. So there are particular circumstances where they kind of merge, but I still think you have to do a basic, this happened, that happened, that happened. It doesn't have to be every procedural fact that ever happened in the case. It only has to be the procedural facts that would be relevant to the matters governed by the appeal.
So there's a lot for our audience in our slide deck about how to write your brief in addition to what to put in it. We're going to just touch very quickly on that before we get on to oral argument. So, one of the things we have to be mindful of when we're writing an appellate brief is, our audience. So Tim, thinking of who's reading your brief, what are some best practices and what are things that you think, we should avoid?
So as far as what to avoid, I think, and it's on this slide here, avoiding sarcasm, hyperbole, pot shots at the other side, those sorts of things. And that was one of my biggest takes away from clerking was, I'm right out of law school and I'm getting these appellate briefs, reading them, and you're just sort of taken aback by what the counsel are saying to each other and how they're characterizing the arguments and characterizing the judge below. And it's sort of like, wow, what's going on? I can't believe how much, vitriol there is between these two parties. And it sort of takes away from, the persuasiveness of it all. And I always found that the most compelling briefs were the ones that seemed to be just very direct, level-headed, even-keeled briefs that almost read like they were, the good guy in the room. And now having practiced for many years after that clerkship, I realized what I didn't know then was that those parties were with each other for many, many years before those briefs are written. They've been through battle together. They've been through trial together. And so that's what was coming through in the briefs. And so if you're in the position of advocate, you have to remember that. Who is your audience? It's law clerks, many of which are just out of law school, and extraordinarily busy judges that don't have time for that kind of stuff. So if you can just write a clear, direct brief, simple language, and just sort of avoid sarcasm or trying to be humorous or taking pot shots at the other side, it's a much more compelling brief, and you're going to do your client a much better service, I think.
I had a partner once tell me when I was a young associate, you need to check every adjective and every adverb. And if they're not really adding to your argument, take them out.
Yes.
So,
Yep.
So Max, Jeff, same question to you. Tips, tricks, rules of thumb that you think people should follow when they're drafting their brief? Max, let's start with you.
Sure. So I do think the tips in the slide deck are pretty on point. You want to be clear, you want to be concise, you want to spend the time necessary. You know, the old saw that is attributed to various authors of, sorry, my letter is so long, I didn't have enough time to write a short one. You want to be sure that you have given yourself enough time to write a short brief, if it is possible to do so, or put differently, to write as short a brief as it is possible to do. The tips about sarcasm, hyperbole, those kinds of things, I wholeheartedly agree with. I will say, if there is one moment of levity or one moment of crystal clarity in an appellate brief that really emphasizes a point, you can, if you feel comfortable that you're at the point in your advocacy that you can do that, that can be very effective, including simply by like causing the reader to be like, oh wow, I can't believe they actually said that. If what you are saying is something that you have earned and you have convinced the reader is true, that might be the best way to cement the point. But you have to be very judicious with that kind of thing. You have to have earned it, and you can't be throughout the brief. It has to be that one salient point that you want to hammer home as effectively as possible. And sometimes bolding, italicizing, and underlining gets very boring to the reader. And a rhetorical flourish that is executed effectively can do the job much better.
Jeff, how about you? Any tips for approaching your drafting?
Yeah, I'll give a few. One is I agree in general, to tone it down for the most part. I mean, my first drafts have often, you write them to satisfy your own sense of outrage, and then you
They're
edit them
cathartic,
down.
right?
Yeah.
But you have to be mindful of the you have to be mindful of the standard of review, right? If you're appealing something, and we talked about the mandamus, right, where you have to basically rouse the ire of the appellate court judges. You have to write in a hyperbolic way. Appealing something where the judge found there was clear and convincing evidence of something, you have to write in a particular way to overcome that standard. If you're appealing something where it involved the judge's balancing of the equities, you need to convince the court that the judge got the equity badly wrong. And you may have to use some adjectives to advance that. So that's sort of point number one. Point number two is the importance of point headings. I believe you should be able to know what the entire appeal is about by reading the table of contents. And that means don't write short, pithy point headings. They're almost like your issues on appeal. And this is a very important point. When I was externing for a federal district court judge after my first year of law school, he taught me to read. Now, granted, these aren't appellate briefs, but read the briefs backwards. Read the reply first, then read the response, then read the opening brief. And that means that you need to write these and structure your brief in a way that you will almost always, there are times where they throw curveballs in the response and you're going to change the order or the focus of your point headings in your reply. But in general, they should mirror, right? Because if they pick up the reply first, they need to be able to understand what the case is from that table of contents. The third point I'm going to make is if your appeal is evidence heavy, like summary judgment, for example, and you're trying to show that there were disputed issues of fact, I believe you do yourself a disservice simply to characterize the evidence and cite to random pages in the record on appeal and force a court to go find it. No, if you think there's something that clearly shows a dispute of fact, quote it in full so that they see it, they know it. You don't have to depend on them going to search for it. And frankly, when I read briefs and I see characterizations like that, I'm suspicious because if it was that good, they should have quoted it, right? And then you go to find it. So you don't want to do it like a million times, but where it's really important, you have to put the precise words of the document or the deposition testimony up there right in front of their face in the brief. Obviously, there's millions more tips, but I think those are pretty important.
Right.
I just want to pile on something that Jeff said.
Sure.
Actually, on a few of the things that Jeff said. One of the things that I often forget when I'm drafting my briefs is when I pick up a brief and I'm responding to it or I'm replying, there's usually been weeks in between the briefs, and I have to remind myself of what's happened, what's been said before. You should remember when you're writing that the reader is most likely going to read them all at the same time. And to the point that Jeff made, maybe in a different order than they were written in. And so that's something to keep in mind as you're drafting, because you may not need to go into quite as much detail on some things, or you may need to tease something out to be sure that it's clear. I also agree about the point headings. I actually will read my point headings as if it was the intro to make sure that it works as an entire telling of the tale. And that's a really important thing. I think that's a really effective way to make sure you have made the points you want to make. And the last thing I wanted to pile on is the characterization point. You should, in an appellate brief, be damned sure that if you say a document says something, it actually says exactly that. Do not stretch that at all. And to the extent you are going to say this is something that happened, you should have a record citation that shows where that happened. And each time you should include that after each one of your factual sentences, because it's my belief that doing that each time and accurately means that you are building up credibility with your reader, so that when they do go check those things and they see that, okay, this guy is backing it up each time, they're going to believe that your version of the events, and therefore perhaps your legal arguments, are the better version and the more trustworthy version. And that can go way further in helping you on appeal than perhaps even some of the other more substantive pieces or more legal pieces of the puzzle.
I mean, I think that last point, Max, is really critical for our audience. You know, you're establishing or destroying your credibility with the court before you ever step foot in the courtroom with your written submissions. And so you have to keep that in mind. And that's not just an appellate point. That's for all of your practices. All right, in the 12 or so minutes we have left, let's move on to what I think is the most exciting part of appellate practice, which is the oral argument itself. So, Tim, let's talk about how you approach it. You're representing the appellant. You typically get to go first. What do you bring up to the podium with you? How much of your presentation are you writing out versus an outline? How do you approach your delivery of your message to the court? And then Max and Jeff, I'm going to ask you the same thing, your approaches to oral argument.
Well, I bring up to the podium with me a manila folder, file folder, and in it I staple an outline that is, it's not written out prose. It's just a bullet point list of points I want to make as I go through my argument. And sometimes it's 2 sheets of paper. When you open up on the inside, if it's going to be a longer argument, more complicated, it'll be 4 pages on each side. But I just have that one manila folder I can stick out in front of me and just use the bullet pointed list to kind of guide me along. The outline itself starts out more as a prose presentation. And as I prepare for oral argument, I just narrow it down just to bullet points. Sometimes the introduction might have a little more prose because when you get up there cold, you sometimes need that crutch. But really, I just try to keep it really simple and conversational.
Max, what are you bringing up to the podium with you?
So in law school, I did a lot of moot court, and I was bringing up exactly what Tim just described. A manila folder that had my intro in the top left quadrant, that had key case sites in the bottom right quadrant so that if I forgot what the case was or what the site was, I could quickly look there. And the idea was I wouldn't have to break eye contact for too long. In practice, I find I am bringing up a manila folder that has more sheets of paper that I look at less. And that's because I know all of this very well. I've been living with it for long enough that I don't need quite the same kinds of crutches. But I definitely have bullet points to make sure I know which points I need to be making and how they fit together. I will also say, and this is a little contrary to what I was just saying about my written submissions, in oral argument, and in particular in my intro, I will be a bit more provocative. And the reason I will be a bit more provocative is I want to solicit a question from the panel as early as possible, because I don't want to be wasting the panel's time giving them my spiel if my spiel isn't what they care about. So I will include something in my intro that might be a little bit of a stretch, not anything that's wrong, not anything that's a misrepresentation, but something that's a little aggressive because it is oral advocacy. And so they can see the context in which I'm giving it. And my goal in saying that is, if the panel hasn't already interrupted me, to get them to do that so that we can get to whatever it is that they really care about, if in the unlikely event that they were being polite and deferential to the lowly lawyer down in the well before them.
And the other thing you don't want to do is just have them listen to you reread your brief.
For sure.
Yeah. So Jeff, how about you? What are your approaches to when you're going up to the podium?
So before I talk about what I bring up, I think, I think what you've basically heard is you don't want to script out, like if you have 15 minutes, you're all 15 minutes. If you get past 2 to 3 minutes and you don't have a question from the judge, from any of the judges, you almost should talk for another couple minutes and just sit down, because either they've already decided you've won or they've already decided you've lost. If they have no questions for you, that's literally what it means. And you would be wasting your time and their time standing up there. I mean, maybe you'll say something if you keep talking that might trigger a question, but that may actually work against you, because it's possible they've already decided you should win and you trigger something that may cause them to think twice about it. So you have to read your panel. That's number one. So you come up, and I think you just want to have an introductory roadmap. It says, I'm going to explain to you that the court should have denied summary judgment because A, B, C, D, and I'm going to start with A, and I'm going to tell you why. Now, what I bring up there is I have a little outline module for each issue, right? And I have a little binder that I use. And then I have another tab that has the tables of content of the 3 briefs, because sometimes the court will ask you, counsel, where was that argued? Or you said that the appellees said this. What page did they say that on in their brief? And you need something to get at it. And I also have another tab that has the tables of authority, because sometimes courts will say, what's the cite to that case? Even though they can just as easily look it up in the table of authority as you can. Sometimes judges are just kind of, running you through a ringer. It happens, right? Where you're supposed to know page numbers and cites and record pages. And the other thing I will have in my binder is, if it's an evidence heavy case, I want the key documents that I cited or quoted from in the brief separately. You can talk about them and you can literally hold it up, right? And, talk to the court, so they can actually, kind of see what it looks like. It could be a useful thing to do. And then the last thing I bring up is I bring up a binder of the briefs, which has all kinds of color-coded flags, just so I know where, what issue it is, where I can flip to it if I really need to. So I tend to bring up more. You don't use, very much of it most of the time. But of course, if you don't bring it up there, that's exactly that one argument
We're gonna
that
need it.
you really needed it.
Yep.
So
All right, so in the 5 minutes or so we have left, let's continue to talk about oral argument. We're going to skip ahead in our outline. And I want to talk about practicing for oral argument, doing moot court sessions. I think, to my mind, one of the most important things, not the most important thing you can do before you ever step foot in the courtroom after the briefing is closed. Tim, how many moot sessions do you typically like to do?
So, as always, it depends on how complex the case is and how much resources the client's willing to spend on it. But typically between 1 to 3. And then always just even if it's just one, I want to have one that is as close to the real experience as possible, where I've got a panel and the panel could be more than 3 people, but have a panel where I'm going to do it timed and they're going to ask me questions and have them read the brief beforehand. And then after that's done, I'll usually just sit down with that group and just discuss what happened and what they liked and what they didn't, and just kind of go over new ideas. But at least one like that, and 1 to 3, depending on how complex the case is.
Okay. And Max, when you do your moot court sessions, are you using the same colleagues or other attorneys to be the panel more than once? Or are you rotating people in and out to get different perspectives?
Largely, I would want to rotate people in and out to get as many perspectives as possible, unless there is some tough issue that we're collectively working through, in which case maybe it makes sense to have the same panel hear how that argument is evolving. But otherwise, just like you're not necessarily going to know who the 3 judges you're going to, or however many judges, you don't know who your judges are going to be on the appeal. And so you can't know what their perspectives are going to be. I think it's useful to get multiple people on multiple panels so that you get different senses of how the arguments play, where things go, so that you can be as prepared as possible for when it actually happens. I will say, as Tim noted, how many moot courts and candidly, even if there are going to be any moot courts, is definitely something that depends on the client and the client resources. And so if you are somebody who is listening to this thinking, my clients could never afford for me to do 3 moot courts, you're not alone, and that's okay. You can do some of the same kinds of things less formally, by conversations, or even by talking with yourself, which makes you look a little odd if you're doing it on the street. But you can nonetheless do this in other ways, so that you still, the moment you are up there in front of that panel, are comfortable and ready to do as good a job as possible.
And one of the things we just touched on was trying to make it as close to the real opportunity as possible, which is including timing your session. So Jeff, do you always time yourself, or do you just allow your panel to just keep throwing questions at you so you can anticipate as many as possible?
no, I don't time it. If they have more in appellate courts, if they're interested and your questions haven't been answered, they're going to keep going past your time. It happens all the time. I want, if I'm, you call it moot courting, I may call it murder boarding. If I'm getting murder boarded, I want to take a beating, because that's where you want to take the beating. If you're answering questions about it for 45 minutes and you're only going to have to for 15, well, you're going to be really ready. And the importance of moot court is in many, but I'll give you 2. One is, when you give a set of briefs to somebody who has no familiarity with the case, you will be amazed at how often they come up with stuff you never thought of, and you're standing there flat-footed. You don't want to do that in the actual oral argument. The place to get hit over the side of the head, by surprise, is in a moot court. The other thing is, you figure out as you're explaining things, oh boy, that took too long. That was not succinct, or that was confusing. And then you can work with the people helping you to, shorten that answer and maybe even write it out. Not that you're going to read it at the oral argument, but if you're the act of writing it out and having it with you, sort of, pushes that succinct explanation, into your mind. So those are, two of the very important purposes of murder boarding.
Right. So we are,
I would just add, I know we're just about out of time,
Yep.
Stephen, but I would just add one thing, which is in the modern world where you can record anything and keep it forever, if you're going to do a moot court, record it, because then you can listen back to it. You will gain additional insights that you didn't realize in the moment by listening to it later.
it's an excellent point, and that kind of segues very nicely into my concluding question to the three of you, which is any final takeaways for our audience that you think would benefit them. So Max, that's an excellent point. That in this day and age, it is very easy to go back and listen to yourself as you practiced and make corrections. Tim, any final thoughts for our audience members?
Yeah, I think, if you're interested in doing appellate work or seeing how it works, reading Supreme Court briefs and listening to Supreme Court oral arguments, I think can help, because you're listening to some of the most experienced folks that do this. The writing's very good. It's clear, direct, and it's usually important cases, so it's easy, fun to read. And listening to the oral arguments, you never know what you can learn, or you might hear some things you don't want to do. So read what others are reading, listen to arguments from other practitioners, I think is a big help.
Jeff, how about you? Any final thoughts for our audience?
Yeah, knowing that our audience is young lawyers, I would have two things. One is if you can associate yourself in some way with an older lawyer to bounce stuff off of and review your work, even if you're a solo, that's an important thing. The second thing is most people forget that appellate briefs, especially in federal court, are readily available. And you could save yourself a lot of time and effort. Like if the key case you're relying on, go read the appellate briefs. All the research you may need may already be in there, right? Not that you're not going to update it. You're not going to straight up plagiarize it, but you can use large portions. We're very rarely treading on entirely new ground in the law, right? There's some element of what we're briefing that has been briefed over and over and over and over again. And if you find somebody who did it particularly well, do it. And it will also give you ideas that you may not have considered without the prompt of reading other people's briefs, even if those arguments weren't featured in the ultimate decision, made by the appellate court. So those are some important tips, especially when you're young and starting out.
Max, let me just circle back to you if there were any others you wanted to bolt on to what you already offered.
No, the only other thing I would add is just like Jeff was talking about with briefs, go watch oral arguments in the court that you're going to be arguing in, whether you go in person or watch them online, watch those arguments. I will also say, at least in my estimation, the more oral arguments I have watched, the more comfortable I am that I can give an effective oral argument. By which I mean to say, you will see a variety of approaches, some more effective and some less effective. And one of the things that does sometimes surprise me is how many of the less effective approaches you might see at a daily argument. And so if you are doing the work to be prepared and to be ready, you should be confident that you are going to present an effective oral argument.
Those are all excellent points. We could continue on and on for another hour. I'm afraid we are out of time. So to our audience, this concludes our webinar. Thank you for joining another entertaining and educational production of Financial Poise. Thank you to our panelists, and everyone have a great day.